Do you want to? I haven't been able to set it up in court. Do you can sit in here if you like, or sit in here if you like. Like you doing something. We're just waiting for everyone to join. There's over 300 people joining, so I'm just asking everyone who's already joined to be patient, please, and we'll start in a few minutes. All right, I've been told that I hope and think that most people are in. Welcome to the Surrey Local Family Justice Board. I'm Alison Rayside. I'm the designated family judge for Surrey. One of the very few advantages of lockdown is that we've learnt to do conferences remotely, which means that we have an awful lot of people joining us, which is fantastic. Last count, we were over 330 people who'd registered. So that's very exciting. My huge thanks to 1GC Family Law, who yet again have allowed us to not only use one of their members of chambers as a speaker, but also have provided the facilities for us this afternoon, because I'm not sure that HMCTS system would manage over 300 people. So I'm very, very grateful to 1GC and to the staff there. We have fantastic speakers. Before I introduce them, a couple of bits of housekeeping. You will not be able to speak, guests, I'm afraid. If you would like to ask questions, there is a Q&A box on the bottom right of your screen, and if you could type your questions in there. After we've heard from the speakers, then we're hoping to have some time for questions. We're hoping to finish in about an hour and a half, that's the plan. And I hope you have settled down with a cup of tea or a glass of wine to enjoy it. Can I just also remind you that obviously the invitation was sent quite widely. 1GC hasn't been able to vet everyone who has registered, and so I cannot be absolutely sure that everyone who has joined is member of the legal profession, or a social worker, or a CAFCAS officer, or a magistrate, or a judge, or a solicitor, or a barrister. So please, can you bear that in mind if you raise questions with us? I think that's all I need to say by way of housekeeping. I'd like to introduce the 4 speakers. I'm going to introduce them all at the beginning. I'm delighted that Dr. Janine Brer has joined us. She is a consultant clinical psychologist with more than 30 years experience in child, adult and family mental health. After qualifying as a clinical psychologist and working in NHS teaching hospitals, Dr. Brer spent 15 years as both a research psychologist and psychotherapist, specializing in assessment and psychotherapy with parents experiencing a wide range of difficulties in caring for their children. A particular area of research development is a diagnostic assessment model for parents in family proceedings, including high conflict families. Lisa Pauling is a CAFCAS officer and a practice supervisor in private law for Surrey and Sussex. She's worked for CAFCAS for 12 years, holds a small caseload of complex cases, many of which have alienation as the central issues, and she supports and advises other CAFCAS officers in the team dealing with aspects of alienating behaviour, and delivers training to children's services social workers around private law work. Richard Jones is a member of 1GC Family Law. He was called in 2003. He practices in all areas of public and private law work, but as Guildford know, he is carving out quite a niche in alienation cases. Both Judge George and myself have had long-running cases where he has appeared in exactly those type of cases, and hence he was my first go-to person. And last but by no means least, Her Honour Judge Lindsay George is a very esteemed colleague of mine. She was a solicitor in commercial practice. The arrival of a family meant that she changed tack and lectured at the College of Law in civil, I think, and civil procedure. She became a district judge in 2010 and began her knowledge of family law then, and is now primarily a family law circuit judge, becoming a circuit judge in 2018. So I'm very pleased that we have such a good panel, and you will stop now hearing from me, and I'm going to hand over to Dr. Brer.
Just need to share my screen. And sorry, it's that's it. Okay. So when we say the words, or certainly when we used to say the words parental alienation, it was known as parental alienation syndrome, people would groan. And based on the original Gardner's work, people would say, particularly to psychologists, this is junk science, you really mustn't be associated with it, it's very bad. And part of that is that his work was criticised because he would see contact resistance and assume that there would be parental alienation. So where there were sexual abuse allegations, there was a big issue of him being biased towards fathers. People felt that he was ignoring the risks of real abuse and genuine estrangement. And in a sense, we're seeing that now with a lot of worry about gender bias and whether alienation is being used as a platform for violent men against women. So I think that's a very similar, but sense that there is a counter culture that worries a lot about over diagnosing. But there has nonetheless been a shift in the grand narrative around alienation. We now see it in the DSM-4 and the ICD-11 in terms of parent-child relational problems or caregiver-child problems. the interesting thing is that what we're finding is actually gardeners presenting symptoms are found. It's just that we have different semantics, we have different emphases. You may find it in a parents are to blame model, you might find it in the child, or in a dysfunctional family relation model. But in essence, the phenomenon itself is now much more accepted. I think one of the things to say is it doesn't have to be overt. It doesn't have to be something that the aligned parent is doing obviously deliberate coaching. What we find is that there's usually some kind of unresolved trauma. I say unresolved trauma, it could be in a parent's own childhood, it could be an unresolved trauma in a relationship. And what's happening is that that abuse or experience of abuse gets transmitted to the child. And, oh, hang on a minute, what's going on here? So the parent's felt sense that the other parent is dangerous is unwittingly sometimes leaked to the child. And the child can sense how negative that parent is about the other parent. And there is some fear of, will this happen to me? So it doesn't have to be quite as explicit as one might imagine. There's subtle collusion by the aligned parent for the child to complain. And the child may, in a sense, be an unaware victim of that process, moving towards the aligned parent for protection, and the parent assumes that protector role. And what happens is you get this awful vicious cycle where the child is encouraged to complain further, even if it's not conscious, and then the aligned parent feels vindicated. I don't know what's going on with these. Why it keeps, sorry. So the child then brings negative issues back from the targeted parent, and of course then the aligned parent feels vindicated. It's like, oh, it really is that bad. Over time, what happens is that the complaining leads to a greater alignment between the child and the, I'm not sure if it would be better to call them alienating parent or aligned parent, but by aligned parent, I mean the alienating parent, and by targeted parent, I mean the one that's being done onto, as it were, the targeted one. Typically, we see it more frequently in mothers as the aligned parent and fathers as the target, but it's by no means all of them at all. And I've had many, many cases where the mother has been the targeted parent. So that's why I'm a bit reluctant to say mother does this and father does that. So over time, the child's complaining leads to this alignment. And the interesting part is the child, in a sense, is encouraged to judge, makes an alignment with that parent and starts to feel superior to the other parent, superior and haughty. And you often see this sense of entitlement and omnipotent in these kinds of children, because there's been a real shift in the family power hierarchy in allowing a child to reject the targeted parent. And I'm sure we'll hear more of this when Lisa speaks. But the problem with it is that we are very used to looking to children and saying, look, what is this child's wishes and feelings? And the problem you've got in alienation is we don't know whose voice we're actually listening to, because the child is unwittingly, in this context, serving the aligned parent's need to reject and punish the targeted parent and turn them from an ex-spouse into also an ex-parent. Because the child's response, the child's rejection of the targeted parent is a response to, if you like, these hidden hierarchies in the family, where the child gets over-empowered by the aligned parent, and their rejection and is colluded by that parent and tolerated. So the problem is that then the child experiences the aligned parent's rejection and hatred and fear and whatever the negative emotions are towards that parent. And there's this big problem, because there's this felt sense when they're at home with the aligned parent that here we have a dangerous other parent, but their lived experience is quite different. And this is the conflict. And the difficulty here is we have a whole raft of psychological literature that helps us to realize that memory, far from being reliable, is actually constructed and distorted. There's a huge amount of research that actually our memories are influenced by shared beliefs, others' accounts taint them, and it's really remarkably worrying that adults, both adults and children, can be induced to come up with false autobiographical accounts, things like saying that they've been hurt or hit or had tea with the prince even. And the problem is that these memories, frighteningly, are indistinguishable from true memories, both in their emotional content and brain activity, which is really quite scary. So what happens to this child? So we've got a number of constructed memories from history that have been changed over time because of conversation with the aligned parent. And as I said, not necessarily absolutely deliberate, but just fear-based conversations that then shift that memory. So then the child has got this conflict between the lived experience with the parent and what they're experiencing at home. So what they have to do, there's a process we call cognitive dissonance in psychology. It's a bit like you've bought a car, actually you've made a mistake. What do you do when you've spent thousands of pounds on this car? What you say is, oh, it really is a good car after all. So what you do is you try and even things up and make sure that you justify. You can't bear the kind of conflict of having done it wrong. So you justify it by making the car a really good thing. Well, it's the same thing when a child's splitting. What they have to do is to try to align their world in some way so that they're not totally confused and conflicted all the time. So what they do to do that is to push away all the positive feelings for the targeted parent and make the negative feelings salient. So how do we begin to look at this? If we're going to do assessments of children and families, there's some good instruments out there now more recently. Apart from the child attachment interview, in which we have to look at the child's relationship with each of the parents, there are also instruments. Amy Baker's come out with an instrument, a self-report instrument, which helps you see whether you've actually got alienation in the child or not. There are cut-off points. Similarly, William Burnett came up with a paper showing that you could use a tool called the PAR-Q to see whether the children were coming up with very extreme versions of their parents, and we'll see why in a minute. But you also want to look at siblings, their social connections, peers, their intellectual level, their emotional profile. So you want a whole battery of understanding what this child's makeup actually is. Are they doing worse at school? Are things happening? And what is the essence of this assessment? Is this: are we seeing alienation or are we seeing justified estrangement? That's the decision that needs to be made when you're doing an assessment. What do we do with the adults? We're looking at family patterns, we're looking at IQ, schoolwork, other previous histories of partner patterns. What's their narrative? What is their parenting style? How similar or different are they? Their values? What's their general temperament like? What were they like with each other? The parents, what's the problem? We're also looking at their personality profiles, mental health, and what we call reflective function, which is their ability to stand aside and reflect on their own mental states and others. Do they have a good, if you like, psychological understanding? And whether the processes that each of the parents are engaging in indicate more alienation versus estrangement. And finally, of course, looking at whether they have the capacity to engage in a process of change. So what do you see in a child? Okay, what's really interesting in severe cases is that you see a child who lacks ambivalence. They're extreme. They're not like, they don't look like other children. So it's quite important to be able to appreciate that what you're seeing clinically is a very extreme version of idealizing the aligned parent and denigrating the targeted parent. And it can be quite alarming. And it often, and unlike other children who have been neglected or abused, you see this phenomenon where it extends to the targeted parent's family. They don't just say, for example, dislike the father, they dislike the entire paternal family and come up with reasons why. Again, very importantly, you tend to see what we call borrowed language or borrowed scenarios that come from the aligned parent. Now, it's very interesting this, because a lot of the clients I see come from fairly intelligent, not huge amounts of poverty when you see this. So you're seeing often children with a fairly high IQ, so that it's quite difficult and tricky to say, is this an age appropriate thing? Because actually their vocabulary may be higher, but it isn't that difficult, because you know that what they're saying could not possibly come from a 10 or 11-year-old. You'll also see what we call reflexive support. You know, I'm on mummy's side or I'm on daddy's side. And you see this incredibly unusual, you get this very compassionate child who's amazingly rude and disrespectful to the targeted parent. And they come up with absurd or fictitious rationalizations. So it's like, well, they know I don't like broccoli and they make broccoli with my food. Or I fell off the sofa and I saw him looking at me with this hatred in his eyes, and he waited 1, 2, 3 seconds because he wanted me to fall. It's like so unlikely to be true that it's absurd. It isn't always as extreme as that. The other issue is you see a child extraordinarily lacking in compassion, so that even when the parent is crying or upset, it's just doesn't touch them, no empathy at all. And the allegations you see are either false or they're tremendous magnifications of fairly innocent incidents. Here's something else you don't see with children who are abused or neglected. Gift turns up and they have a panic attack and they don't want it. I mean, what child doesn't want a gift? You buy them their favorite gift and they reject it. They don't visit on special days like Mother's Day, Father's Day, and they behave really miserably and anxiously. They might even spy on the other parent and report back. And they start to move into an arena where you wouldn't expect them to for a young child. Fine, if a child's 15, 16, you might say, okay, I don't want my mother and father to know about my medical records or what I'm getting in my grades, but you don't expect it from an 11, 12-year-old. So they only want their mother to see it, not the father. Or they make the other parent a persona non grata at school events. And another fascinating thing is when you say to them, well, you know, look at these pictures, you obviously loved your mum a lot a few years ago, you can see you were having a good time. Yeah, well, she was fake. She was just being fake. It wasn't real. So you see this concept of fake love. And the other thing you see is that you say to them, well, what if they changed this, that, or the other? And they say, no, there's no way in which this relationship can be repaired. And you don't see that. When children have been abused and neglected, they're desperate to be loved again by the other parent. They really want it to be repaired. And they don't, and these kids just don't. So the other very unusual piece is it's alarming how much hatred that these children will express towards the targeted parent. And then when you have done the intervention work that you need to, very short, where you basically get the aligned parent to shape up and say, you will make this okay for this child, you then find that with your reunification, it can be gobsmackingly fast, where the child will literally hop on the mother's lap or hop on the father's lap and say, hello, daddy. And it's like, no, I'm going to kill myself if you make me go back there. And suddenly they're absolutely fine. And whether it's a few minutes or a few hours, often we say it can take 4 days, but I'm saying sometimes it's remarkable how quickly. And then, of course, they flip back again in this process called splitting when they go back to the aligned parent. So the other big thing is that what we see is a child seemingly functioning on the surface. So you kind of, a lot of social workers and guardians who don't know about this process will say, look, they're doing really well, you know, with the kind of, don't move them, don't do anything. If it ain't broke, don't fix it. But underneath, there are huge problems actually when you look psychologically and their functioning. This split that I've spoken about that they're trying to heal means that they have very poor reality testing and very distorted interpersonal perceptions. They have very rigid black and white processing. So their conflict resolution with friends is affected as well, with other people. And you see that they become extreme in themselves. They're either extreme internalizers, becoming really anxious or depressed, or externalizers with aggression and behavior problems. They have what we call very poor differentiation of the self. They're enmeshed with the aligned parent, and their wishes are the parent's wishes. It's very hard to actually see a sense of self. And I've spoken about this entitlement. So you see them, this pseudo maturity, as we call it, of great entitlement, or there's a lot of self-hatred. Now, why do we worry so much about these children if they sort of seem to be all right and we don't want to move them? Because in the longer term, there are such significant mental health issues. We know that they have not only great difficulty forming relationship, but there's a huge increase in the rate of depression. You get substance use, anxiety, impulse control issues in adolescence, self-hatred and self-esteem. Amy Baker's work has shown us just how miserable and guilty and dreadful these children feel in their 20s. And the saddest part also is that it doesn't stop. It continues often in the next generation. And so it's not unusual in these cases to see a prior history where there's been poor conflict resolution. Now, here's the big problem with alienation. Everything is topsy-turvy. You can't do conventional therapy, right? You don't give these children conventional therapy because where you sit them in a room and you give them empathy and you allow them a voice, what does that do? It just cements the false nature of their beliefs and their false memories. There's a lot of evidence from more than 1,000 cases that if you give them conventional therapy, it just doesn't work. You don't get restoration of the relationship. Sure, if you want to try therapy, I'm not saying don't try. There are some cases in which you might just be lucky if you catch it early enough, but on the whole, don't give it too long because it doesn't work. So give it a chance, but don't use your best therapists because it's probably likely to fail. You're better off to save your best therapists for the actual intervention that's likely to work if you think there's a serious risk of alienation, because slow steps to develop new patterns just don't work, and they stop the opportunity for doing real work that works. And if you think about it, these children are being exposed daily to psychological harm, whether it's inadvertent or otherwise. There's a big imbalance in power and control. The child's over-empowered, the targeted parent is weakened. What is 1 hour of weekly therapy going to do compared to the rest of the week of that influence? And one of the main problems is very highly experienced conventional therapists with many, many years, even experts who are tremendously competent, may miss the red flag signs. And that's one of the key worries. And in my experience, and the evidence would agree, broken attachment needs very swift protection from further harm, swift correction, and you really have to have specialist critical approaches. Now, the evidence suggests that you need court-mandated therapy with sanctions for effective resolution. It's best implemented very early on before you've got severe alienation. If you can do that, then you don't have to transfer residence. You may get some very good results from a shared care program. But if it's very severe, there's just no other solution. Unless you can mobilize the aligned parent to work with you and leverage that power to make a difference, you're going to have to separate the child for a short time from the aligned parent. It's transient, but we know apparently it's not harmful. But before I say that, clearly there are individual issues that need to be understood. Does the targeted parent have the capacity to actually manage the process? Sure, we know out of the aligned parents' orbit, the transformation goes from staunch resistance to love fast. I've mentioned that. The problem is if you've got, and I don't mean this unkindly, you haven't got the most sensitive targeted parents. Not everybody can be easily targeted like this. And my experience has been that a lot of these targeted parents are less, if you like, sensitive. Now, I say sensitive, they may be less sensitive because they've had very early experiences in boarding school, or they're maybe slightly on the spectrum, slightly autistic, or slightly borderline authoritative parent moves into overly rational, not necessarily super sensitive. So they're much more vulnerable, if you like, to being manipulated by the other parent. So what do you need to do? You need to provide psychoeducation, you need to protect the child from harm, reduce the child's distress, and you have to challenge the child and the aligned parents' distorted thinking and teach the child critical thinking skills to stop idealizing and denigrating. You have to repair the relationship, support the aligned parent to make changes with conflict resolution techniques, win-win, and establish healthy boundaries. That's why the evidence, I should say at the outset, is not brilliant in the sense that there is evidence, but we'd like evidence at the level of systematic reviews. We've probably only got evidence at the case study or cohort studies level. So it's not brilliant, it's not hopeless, but it's not great. So how do we help them? And this is the big problem. Who do you send? It's great. I'm stuffed with referrals to make assessments of these families. I'm turning away work constantly. What can I do when I find there is a problem of alienation? There's almost no one to refer these people to. The problem is that people don't particularly want to work in it. When they do work in it, they leave pretty quickly, because the problem, and would say in the 300 people who are participating, if you've ever worked with these cases, you'll probably recognize what I'm saying. They're toxic. There's a mistake because you see it as heroes and villains. The aligned parent becomes the hero, the targeted parent the villain, but it just as easily flips. It can easily flip when you put a transfer of residence in place. If you just leave it there, you can get counter alienation. And the problem is that there's a process we call transference, which is a psychological phenomenon, that the anger and poison of the relationship literally leaches into the professional team. You can find that the team become venomous against each other. And so peer supervision is really key. One of the things that I'm thinking of doing is getting some using a clinical supervision model with lawyers, where people, I'm not sure how it would work because of the whole issue of independence and confidentiality, but I think people need support. There are risks, it's not all over. You get parents who say transfer of residence, you get fights to say transfer of residence. Yes, sometimes it's the thing to do, but there are risks. Residence transfers can fail. And people are appropriately afraid of labeling a case as parental alienation when it's not true. Saying that, it's just as worrying if you don't actually pick it up when it's present. And all of these issues do impact on recommendations. You've got to look at the competence of the parent you're making the transfer to, and look at whether it needs to be, whether it can be temporary, whether you can then move to shared care. Nonetheless, it does need a swift, intense, creative approach. So based on evidence, I would say the model that needs to be used, and I would say you don't want to use this model if you don't have clear findings of alienation. I'm not very popular when I ask for a fact finding, and particularly at the moment, because there's such a delay. It's not that you need a fact finding process per se, but you absolutely need a clear truth. This is alienation. This is not abuse from a judge, in order that you can actually say to the aligned parent, you have to stop this, or we're going to remove the children, because this is emotional harm. And you can't do that. And it goes on for years of intractable hostility if it's a sort of, oh, well, she's sort of alienating, but, he's not. And that's the kind of case that goes on for years, and which is why I want a really clear outcome. It either is or isn't okay. It either is or isn't alienation. You have to give the parent a last chance saloon. Now, I'm not saying that there aren't hybrid cases. There are definitely cases where you've had smacking, a degree of controlling coercive behavior by one parent, and then you have on top of that a layer of alienation. They're very complex, okay? They are complex cases, and I'm setting those aside for a second, if I may, because you approach those slightly differently. We're talking about straightforward cases. You need to give the aligned parent a last chance saloon to change, and you may need a suspended transfer of residence. If that parent is really delusional and the assessment comes out and it really looks so poor prognostically, then you may have to do a transfer of residence anyway. But I really will generally want to err on the side of last chance. Get it together, have a 3 to 4 month intervention, try to get co-parenting done. You have to have the court holding the case, because these people sabotage, and there's no point in ordering therapy and then they'll go away and they'll sabotage and they won't go, and there'll be umpteen reasons why not. You have to get the practitioner to provide a report to court, so that both parents are under no doubt that they have to behave well. And do you know what the thing is? Even if parents are behaving well for the wrong reasons, it can become a habit. Doing the right thing for the wrong reasons can sometimes become doing the right thing and a habit. I often get people to sign a consent form, which probably isn't worth the paper it's written on, but it helps to say, because often aligned parents will try and sabotage the process by making a professional complaint. So I ask that the complaints process goes through the judge, so that the judge judges initially whether there's been some real problem here before they make a complaint. Okay, so what do you need? You need a comprehensive screening, you need a report on parents' psychological profiles, the children, and capacity to engage. Typically, you want a contact trial as soon as possible, therapy reunification, and then you evaluate whether the aligned parent is actually going to play ball. You swiftly escalate contact, and we're talking days, 1, 2, 3 weeks, short window of opportunity, get the children away with the targeted parent for a weekend away, building up very quickly. And then you're looking at the aligned parent's capacity to move genuinely towards becoming a positive influence, because there is absolutely no doubt that the aligned parent has all the power, all the leverage. And if you can work with the aligned parent and get that parent to acknowledge that they've made a mistake and actually have part of that being the therapeutic process, there is no better solution. Then you evaluate child arrangements. Within it, you have to have a parenting coordination trial. I think that temporary shared care 50-50 is the best solution, because then you can make your therapeutic intervention all about fairness, integrity, win-win. There is no battle. It's about being fair to each other. Children like that idea. They generally like to play fair with mum and dad. You need to develop a parenting plan. CAFCAS have a good model for that, but it's essential. And I find with these people, a vague parenting plan doesn't cut it. It has to go from literally, I would like my emails answered within X amount of time. I would like X, we need to have this amount of uniform each. You will return this. It needs to identify the detail and the parameters. Otherwise, they find loopholes. And as I've said, you need a report and a child arrangements review. The thing that I make use of, and I kind of wish I had a share and a stake in it, but I don't, is Our Family Wizard, which is an app in which you can put a practitioner in there to monitor the parents' communication, which means that the therapist has access to real time and can stop things escalating very quickly. Children can have accounts, but they can't see the parents. And the wonderful thing about this, I think there are a number of these apps, but this is the one I happen to know. You've got a calendar that's red and blue so that you know whose is who. It's nights. It just takes care of a lot of arguments. There are message boards. You can't wipe it out because you can fake WhatsApp messages. There are journals where you can put things up so that people don't bombard each other with messages. You can say, look, it's there if you want to see it. There are expense logs and other things like that. And they've also got this thing called a tone meter, which picks up, it's kind of a nice artificial intelligence thing that picks up and says, that sounds passive aggressive, reword it. Now, it doesn't stop you sending it, but it does mean that it gives the parents a chance to change it. And then we get to the next bit, which is completely missing in this arena at the moment, is how do you sustain change? I tend to see these cases as what I call family cancer, I'm afraid. It's a pattern. You can get it into remission, but it never completely goes away. So I think monitoring and some sort of ongoing evaluation is key, even if it's proactive from the parents. They need to be able to reaccess or they'll be back in court. Something like a supervision order, because people move from compliance. The aligned parents will move from compliance, where they're doing it because they're being watched, to a process called identification, which is you're doing it because you want to be that kind of person, but actually you'll have a secret left with to your own devices. You haven't really taken it on board themselves. Internalization is really genuinely taking it on board. You want to be able to gradually withdraw, but how do you know when it's sustainable? In truth, I'm not sure. As I've said, I think that when you have an aligned parent doing this, I have had parents who have seen the light genuinely, have had eureka moments and have said, thank you so much. I really didn't realize I was doing this to my children. I adore them. I had no idea there was this level of mental health, and it can happen. But for others at the other end of the extreme, you need a suspended transfer of residence probably for the child's minority. But what you do need to sustain change is a lengthy period where they are able to integrate new habits. That doesn't mean 18 months of daily therapy, but it does mean that you're kind of around, or someone is around. So, and my final piece on this is there are too few reliable practitioners involved. I think we just need a fundamental change in the system to bring high conflict families who are creating this level of significant emotional harm to children into local authority child protection practice. I've had a handful of local authorities who have got involved and been stamped on by wealthy parents, and they've very quickly dropped everything and run scattering back into the background. And it's very difficult if they don't give your intervention teeth. They need to learn to recognize red flags. There needs to be intervention and ongoing monitoring. And that is the only solution. I'm very excited to know now that CAFCAS, that wasn't part of what CAFCAS were doing a decade ago. There was no one. And it's so good now that it's becoming more mainstream. And that, in my opinion, is what needs to happen critically and urgently in this area. That's it. I'm done. I'm just going to stop screen sharing. Okay. Has that stopped the screen share? Yeah, okay.
Yes, it has, yeah. So I think I'm next, so I will now also share my screen. Okay, so I'm hoping everybody's seeing my screen now. If somebody can just let me know. The CAFCAS logo's come up. Great, thank you. So yes, I'm going to talk about this from the CAFCAS perspective. In 2000, I think before I start, I would just like to reiterate what Janine had said about the absolute essential need for a fact-finding hearing in these cases and early on, and it's going to avoid so much delay for the children and hopefully finalising and making decisions for them when that we've got some sort of factual matrix to work with. So it is absolutely essential in my view, and when I'm in the cases that I work and my consultations with other workers, that's something that I'm asking them to flag up to the court immediately, the need for findings on alienating behaviour, on is this alienation, and findings on the allegations that are made by often the resident parent, the alienating parent, so that we've got something to work from. In 2018, CAFCAS launched the Child Impact Assessment Framework, which looks at all aspects of issues, welfare issues and risk issues that come into family law proceedings. And there's a whole section on alienation, or what we would call resistance and refusal of a child to spend time with another parent. And so the family court advisor or the guardian, often in cases a case becomes a 16.4 and there's a guardian appointed. And firstly, we are looking at why is this child refusing or resisting a relationship with a parent. Is that, Janina touched on this, is that appropriate? Is it justified rejection? Is it something because of their lived experience, domestic abuse, exposed to domestic abuse or other harmful parenting styles, so substance misuse, mental health, etc. Then there's probably some more subtle aspects of it where a child has an alignment to a parent, and that may be something that happens, early on in a separation, where they feel that, that they feel more aligned with the narrative that one parent has given of why this relationship has ended. There may have been an affair, there may have been a big argument on separation, and they're clearly they're aligning themselves at that time with the parent that they're living with. And then sometimes with younger children, there's an attachment. There's that need to be with their primary caregiver, the person they're used to being with, and making that step from daytime contact to overnight contact can sometimes be difficult for the child, and also difficult for that parent to promote. And then we have the alienation, which we're here to talk about today. But also we can't forget harmful conflict, and some children are exposed to so much conflict post-separation. Conflict at handovers, conflict when the text message comes through, when the video call comes through, and there are points where children just start to refuse to spend time with the other parent, just as a means of protection from this ongoing conflict that they're exposed to. So they're using that as a way of stepping away from that conflict. So we're looking at this from, we're assessing what this is for the child's lived experience, the impact of the parental behaviors on the child, whether they are, they're on a scale from something mild to severe, when we are talking about significant emotional harm. And there's all the whole child, the child's world needs to be looked at: their age, their relationship with their siblings, their vulnerabilities, their emotional well-being, wishes and feelings. Again, Janine touched on, we know that when we're doing our day-to-day work as a CAFCAS officer, the wishes and feelings are central to our work. But when we are moving into the realm of potential alienating behaviours, we know that those wishes and feelings are loaded. We know that they are influenced. We know that they are enmeshed in that resident parent's views. And I think that word about that sense of power, that sense of over entitlement that a child has, that you must listen to me. I don't want to see that other parent, and I know that I'm right, and I know it's your job to listen to me. So that is playing out in these cases, and it takes some real skill to unpick what is really going to be the child's wishes and feelings, or whether that's mirroring and enmeshed in the resident parent or the alienating parent's worldview. And also the level, the intensity for the child. So is it intermittent? Is it something that happens, in a passing comment once a week? Is it something that is just eating away at a low level, or is it really an absolute campaign by that parent, showing, to completely deny this child what would be a loving relationship with their other parent? And often what we see is the difference in the parent in the parents that we're working with. So some of these parents are able, with the right resources that CAFCAS have. We have the CAFCAS Positive Parenting Program. We have what was CCI, that's now moved to a new service called Improving Child and Family Arrangements. We have the CAFCAS Co-Parenting Hub, parenting plans. So working with these resources, sometimes these parents are able to reflect and show some level of empathy and consider the harm that the children are experiencing when they're being denied or not giving that emotional permission to spend time with their parents. And then we can use those resources, and we see with a persistent alienator, with somebody who has a campaign against that other parent, they can't show empathy, they can't reflect, they can't see the harm, no matter wherever we go with these resources and with these skills that we have to try and shift that parent, it's just not going to happen. So within the CF, we've got some tools that we've developed, and I would really encourage you, people that are interested or haven't already, to look at the CF website and the CAFCAS website, because this tool is a really helpful tool for practitioners. I've seen it used by barristers to cross-examine, for example, a local authority social worker who hasn't been able in the work with the family to recognise the harm that a child is experiencing. Because again, like Janine was talking about, they're going to school, they're going on holiday, they're functioning really well, they're articulate, they talk about wonderful family times, a lot of things are going well for these children. So it's about helping practitioners unpick this a bit more. And so that's broken down into 3 areas where there's some questions to consider about the behaviours that a child is demonstrating who has been alienated, and the behaviour of the parent that is the resident parent, and the behaviour of the parent that is being has been alienated by. So just to give you a little example, there's about 10 questions in each section, and you're looking at it. These questions, you're saying, are they happening? Do they never happen? Do they sometimes happen? They're intermittent, they're regular, or that's something we don't know and need to seek further information about. So, a child's opinion of the parent, of the non-resident parent, is unjustifiably one-sided. All good, mum's all good, dad's all bad, or the other way around. Idolizes one parent and devalues the other. A child that revises history to sort of eliminate and diminish any positive memories that they may have had, any beneficial relationship that we know they probably had with this parent, but that's all gone. And then a child that reports things that, events that may not have, that they possibly could not have remembered because it would have happened when they were so young. So some of the questions asked for the parent that is showing the alienating behaviour, they refuse to hear positive comments about the other parent. They're quick to discount any memory a child might tell us about as being insignificant and unimportant. They don't correct a child when they're rude or defiant about that other parent, where normally if that child, within this family, if that child was rude or defiant about another member of the family or a school teacher or anybody else, that parent would pull them up. But when they behave like that towards their other parent, it's ignored or even supported. And a parent that shows their own emotional distress and fragility, like exposes the child to that at point of handover or pre-contact when they get back from contact. So exposing the child to their own issues, really. And then some of the questions for the parent who is being alienated, that has lost that relationship or losing that relationship with their child. They can sometimes lack some empathetic connection to the children. They can lack understanding of their age and development. And, sometimes they also attempt to induce guilt or make that child feel somehow that they are bad for behaving this way. So this is a tool that we all use when we are looking at when we've got alienation as an aspect of our assessments. So the FCA, we're linking our analysis to the recommendations that we're making to the court. We have to give a full analysis about what is contributing to this child's negative belief systems about their non-resident parent. Before we label it or as alienation, we've got to look at all aspects of this child's lived experience. Reviewing all of the possibilities of what has caused this resistance or refusal to spend time with a parent. Maintaining a focus on the impact of the child, and most importantly is evidencing the significant harm, so that if alienation and behaviours of that parent is alienating the child from the other parent, this is really harmful for the child. And Janine spoke about some of the long-term impact for these children. It's recognising that and setting that out for the court. providing a really concise description of both the child and parents' behaviour, which is informing our analysis. And you know, it's a balance sheet. We're thinking about the parent's capacity to change, what is giving us an indication that that parent is going to be able to change and change within that child's time frame. So very quickly before this behaviour becomes embedded in this family. We're looking at that previous positive relationship. What have we got to hang this on? You know, what memories are there? What can we revisit with the child? If we are looking at a change of residence, you know, is this parent, it's the parent's capacity, you know, the ability to be attuned to the child's needs and to pick up where the other parent is left off and nurture this child in the right way. And how is this child going to cope with any change that we are considering to make in their lives? And how will that impact their world in terms of their wider family networks, possibly looking at a change of school? You know, there could be quite significant cultural differences in different households. So looking at each child's individual world and what the impact will be. So yeah, the next steps, once we you know, we've had a fact-finding hearing, we've applied our assessment tools, we've had a finding of alienation. The next steps, you know, it's really tricky. It's really tricky. Some of the things that I think that have worked in cases that I have either worked or that I've supported other FCAs in is developing a child-friendly narrative or judgment. So a child-friendly judgment. So the judgment of the fact-finding hearing delivered to the child in an age-appropriate way, or an agreed narrative from the parents about why this child hasn't been seeing their parent. Asking for a Section 37, it's imperative that we get the local authority on board. It's imperative that we get the local authority understanding the harm, the significant harm that these children are experiencing and the need for their involvement. An expert assessment, Janine's talked about what we need. And again, I go back to the absolute need for that fact-finding hearing before we go into that expert assessment, so that that expert has got something to work with, to pin their assessment on. And then the intervention. And again, if we've got the local authority on board, we've got more resources to look at the intervention. But yeah, that's all I've got to say. But just to underline again what's been said, these are really complex cases. They're really hard for practitioners to work. They are toxic. They're challenging. There's not always an easy answer, and you know, and it's a complex piece of work that there's often no quick solution to, and no end immediately. It takes a long time to resolve. That's me.
Just to remind everyone that a recording of this talk will be available from the 1GC Family Law website, and you can request the same by emailing 1GC Family Law. So just in case you worry about taking notes, etc., you can get those. I just wish to begin, because I'm going to talk about the law, but I just wish to begin with this strange picture, not of myself, but of a man balancing, because it's an aid memoir to me in terms of the cases that come through your door, because I appreciate that the title of this is Myth, Reality or Nuisance. And I know full well that you will, as practitioners, be having people through your door who are not only saying, I've been alienated, but also those who will come through the door genuinely and legitimately worried, because they're saying, well, my other half is saying that I'm alienating. I am not, but I'm really worried because this is something that the courts are very switched onto. And I'm really worried as to how I fight that, because I don't know what to do. So I just wish to be clear from the outset that I've tried to approach it in a balanced way to assist you in terms of those who allege alienation, but those who actually are trying to resist not only a finding, but the general allegation in relation to alienation. And I thought a very good place to start in terms of people coming through your door would be this case of Re M from 2017 from the then President Sir James Mumby, because in terms of beginning at the beginning, people who come through your door for advice have, of course, very often no familiarity with the family courts. They don't know what goes on, but very often they come with preconceived ideas. They know about their friend down the road who's been in the family courts. They know what happened to them, and they have from that an idea of what's going to happen, which is very often completely misconceived and not grounded in anything. So it seems sensible to begin with this case in terms of being able to be upfront with clients as to what to expect. And I think it is crucially important for clients to know, both those in terms of who allege and those who are trying to resist any allegation of alienation, to know exactly what it is to expect from the courts. And I think that this case emphasizes more than anything else and what it says, the positive obligation that falls on the court to promote that relationship between a child and their parent. And of course, as Janine made plain at the outset, this, of course, goes far deeper. The judge, as it says, the then president said, must grapple with all the options. And the reason is because, of course, the damage that is done to a child not to have a relationship with a child, with a parent, if there is no good reason, has, of course, not only short-term damage, but medium and long-term. And what we're talking about here is a package in terms of a relationship between a child and both parents, and of course, both sides of their family. And that can very often involve, of course, half siblings as well. And that is something in terms of the package is important, because of course it does affect a child's identity. So I think this is an important element for clients to be aware as to what to expect from a court. But perhaps most pertinently of all to this talk is the part that was later added in terms of a warning, a health warning as I see it, in terms of, as set out, judges should be very reluctant to allow the implacable hostility of one parent to deter them from making orders. If there is any hint of implacable hostility, it must be dealt with swiftly, and it must be dealt with quite severely in terms of there being a strategy. And I've put in the cases of Re R, which is a decision of Mr. Justice Williams, and the decision of Re Q, which emphasizes again and again that when there is to be a set strategy by a judge, that strategy needs to be stuck to, because both parents need to know that that is what the court will expect, and that if orders are not obeyed, there will be consequences. And of course, the time for considering if there will be consequences for the breach of an order is at the time of making the order, not afterwards. So it's a clear, if I may say, health warning in relation to implacable hostility or alienation. So once someone's come through your door, how are you going to deal with this? Well, the now president set out in the case of A from 2013, what I think is a very good aid memoir for when the matter goes to court. There has to be judicial continuity. There is simply no way around it in relation to cases of alienation, because we all know that a judge, say with any individual, may take a particular view only on the next hearing to be replaced by a other judge who takes a completely different view. So at the very beginning, it needs to be very clear on the face of the court order and in terms of dates that there is to be judicial continuity by a particular judge, or indeed if it's a bench, of course, in relation to those sitting consistently on that case. There also needs, from the lay client's perspective, needs to be clear expectations. And that does feed into case management and timetabling, so that they know by X date, so many contacts need to have taken place in a certain way, and what message is to be given to a child. And that does feed into the case management, but also the set strategy, which will be set down, of course, by the judge, because the judge will have a particular date in mind by which they expect a certain narrative to be communicated to a child, or, of course, as I say, certain contacts to have taken place. And of course, if you have this continuity, then it's much more able for the practitioners to have oversight in terms of compliance, which does feed into, of course, a consistency of approach, so that the clients themselves know exactly what is going to happen when, if they do not comply. This is a decision I just wish to bring your attention from His Honour Judge Wildblood QC in the case of A, which was a very long and distressing case in relation to alienation, but he did set down some markers in terms of assistance. And I can see from the feed that we've had a few questions in relation to, well, how do we deal with these speedily, and how do we get in circumstances a quick fact-finding hearing? Well, one of the ways that I've found certainly in dealing with many of these cases is to bring the law, and in particular cases such as Re-A, to the attention of the judge, the trial judge, to make perfectly plain that unless this is dealt with speedily and dealt with as a matter of the utmost seriousness, with serious emotional harm consequences, then of course there will be very, very serious consequences. So on that basis, you should be asking the court to deal with it speedily in terms of a swift fact-finding hearing. But one thing that you'll see in the second column that is emphasized is, of course, a collaborative approach between professionals. If you have the local authority involved, if you have someone offering specialist counselling, if you have a school that is very involved, or if you have a specialist CAFCAS officer involved, there needs to be joined up thinking so everyone has A, access to the same documents, and B, they know who is seeing the child and when. Because sometimes with professionals, a child can be overburdened with a number of professionals. And secondly, in terms of what they're saying, there's a discrepancy. There does need to be joined up thinking, and this is to be dealt with as part of the judicial strategy, as part of the case management, and it needs to be plain in any order, and that order needs to be served on the relevant professionals so that they know precisely what is expected of them. And on that point, it is also important for professionals to be signposted in orders as to who it is they are to speak to. All too often, of course, we hear back where the professional had not spoken to X, hadn't spoken to a particular teacher at school, hadn't spoken to the nanny. Well, very often that is unfair, because the professional needs to know precisely what is expected of them. And I have found the best place to have that take place is the court order. And of course, has already been touched on by Lisa, again, the fact that expressed wishes and feelings obviously cannot be taken at face value. So in terms of urgency, this case of His Honour Judge Wildblood is, I think, a very useful one to bring before a court. And likewise, the case of Re-S, which is a Court of Appeal decision of Lord Justice Peter Jackson. Again, when you have someone come through your door in relation to parental alienation, and they say, well, what does it look like? I personally have found this useful to bring to clients' attention in terms of, well, these are the examples. This is either what you're saying, this is what you said in your application about the mother, or it is useful as well to say to a resident parent, well, this is what's being alleged, and this is in short what they say you're doing. And it's useful because then you can meet it. If, for example, you're for a parent who is worried about the allegation of parental alienation and is desperately trying to, as they see it, clear their name, they know that things like suggesting that the other parent does not love the child and contacting the child excessively when with the other parent are red flags. So that they know that they can meet those and they can actually build a constructive case. What do I mean by that? Well, for example, not contacting the child excessively, or for example, ensuring that there is a photograph of the non-resident parent, for example, in the child's bedroom to reinforce a positive message of that other parent. So that when you're constructing your case to meet any allegation of parental alienation, these are the positive building blocks that you can bring before the court to meet any such unfounded challenge. Again, I put this quote in again from Lord Justice Peter Jackson. It's exactly the same case. It is a welfare decision. And of course, what is at stake here could not be more serious. Irreparable harm to be done before appropriate action is taken. So again, a useful case if you're trying to convince a court to list the matter speedily in terms of a fact-finding hearing, because there is only a short window very often and the stakes are so high. So again, a message not only from the circuit bench, but again from the Court of Appeal of how urgently these matters need to be dealt with. And I think that again is very useful to bring before the court. We've heard already about the importance of a fact-finding hearing. I emphasize that it's not a case of one size fits all, but where possible, there should be a fact-finding hearing at an early stage to assist the factual matrix so that professionals know precisely what they're dealing with, that the lay clients know precisely what the findings are. So it's no good them saying, well, that's not true, or I believe this, that this is what's been found by the court and this is how the matter will proceed. Again, in terms of instructing experts, I can only reiterate what's been said by Janine about the importance of getting expert evidence of professionals who are skilled in this area. And the same goes, of course, both in terms of CAFCAS officers and, of course, social workers. There does need to be clear experience in relation to dealing with cases of parental alienation. I only wanted to bring this case very briefly to your attention as a health warning, because in this case, in Reed J, where the father in fact acted in person, the circuit judge did not conduct a fact-finding hearing in relation to allegations and counter-allegations that did fall under Practice Direction 12J, where there was an issue as to why the children did not want to see their father. And the Court of Appeal made it very plain that there does need to be a factual matrix before the case proceeds any further, or, for example, before there is any expert input. Instruction of any expert needs to be very plain. The judgment needs to be the starting point. If there is one, there needs to be clear instruction as to what is expected. And of course, ultimately, what the court is concerned with is a balancing exercise in terms of if there's to be a transfer of living arrangements, and that needs to be set in the letter of instruction so that the expert can, of course, look at all the elements of balancing that the court will ultimately have to look at. And I just want to pause there, because the one point of ensuring that the expert has full access to medical records of the parties and the children, and I pause there deliberately, because one element of parental alienation that is seen so often is a resident parent will deny the other parent parental responsibility. So it is worth having an eye to medical records. It is worth having an eye to school records in terms of what unilateral decisions have been taken by a parent without any recourse to the other parent. Very often such records do speak volumes, that they basically have bypassed that other parent. And that very often is useful evidentially in terms of any fact-finding hearing. I cannot overstress this decision of the President from 2019, because I've only recently seen an expert report which speaks of the transfer of living arrangements in a parental alienation case as an option of last resort. No, it is not. And it is perfectly plain that the test, and always has been, a holistic approach to the welfare checklist. No more, no less. And that is made perfectly plain in this case. A number of occasions that I have seen reference, even now, to last resort in terms of transfer of living arrangements is quite shocking. So I really do stress that this is a case to have in your arsenal in terms of it being a welfare-based decision, and it is a balancing exercise of the options. Now, if you'd, I know, and I know there's many questions in relation to what do you do, how do we hurry this along, or a case has got bogged down in a county court, it's not moving forward. The experts aren't doing very much. The social worker has only met the child a few times and says, well, this is what the child's saying, there's not much more we can do. Well, just be mindful of what I've called the toolbox, because there are very many ways to deal with this type of situation. I'm afraid I'm not going to take it in order, but I'm going to take it in order of, as I see it, the importance in terms of the questions that's been asked. There's been reference to Section 37, local authority involvement. Well, the case of H, which is a case that both myself and Janine were involved in, if you read that judgment, you will see that the social worker and the caseworker had not a great deal of experience in relation to parental alienation, and did, as the judgment makes plain, take wishes and feelings at face value. So in terms of the tool, it is, as I mentioned before, so important to ensure that if there's a social worker, expert, or even CAFCAS officer or NIAS caseworker, that they have the experience necessary, because you don't wish to end up in a situation of what I call public shaming, as occurred in the case of Re-H. Also, an underused tool, if I may say so, is that of wardship. Wardship was first mentioned in the context of parental alienation by Sir James Mumby in Re-M, but perhaps most recently was used by Her Honour Judge Rayside, sitting as a Deputy High Court Judge in the case of T, Parental Alienation 2019. And we have all had these circumstances where a case does get bogged down. It goes for review after review, or directions after directions, and there is very little progress made, or you can't get the fact-finding hearing speedily, or even a final hearing, because there's got to be some more input. And it goes on occasion for years. And this is a useful case where wardship was used to take it quite literally to the High Court, so that the matter could be expedited. It was taken at a very serious level, and of course Her Honour Judge Rayside in that case made every effort to ensure that the matter was very speedily dealt with, and that a contested hearing, both interim and final, took place very speedily. So do not shy away from using the tool of wardship. And again, suspended transfer of living arrangements. Most recent case is Re-R, Mr. Justice Williams. The threat very often of transfer of living arrangements, A, for those parents who are worried about what will happen to the child who's living with them, or those who just want to have contact with their child in a normalized way. Again, that is a useful tool. as well, of course, as the ultimate weapon of immediate transfer of living arrangements. The court does have that power. At a final hearing, and this, again, I cannot overemphasize, you've got to a final hearing, you're saying there's parental alienation, perhaps it's already been found, and you're seeking for a transfer of living arrangements. Well, just pause there, because you're asking for a transfer from a parent who a child has lived with for so long to a parent who very often the child is hostile to. And you need to ensure that there is, this is my term, I admit, a soft landing in terms of therapeutic support for that child in the home that they are going. And that specialist support needs to be absolutely tailored to that child and that parent. I cannot overemphasize that. And of course, to know how that transfer is to take place. In the case of Re-H, there was a specialist independent social worker. And I know that in a other extreme case, more recently, the TIP staff even assisted in ensuring that there was a transfer of living arrangements. But I cannot overemphasize, you do need to ensure that there is every preparation in terms of the home that you want the child to be transferred to. And of course, if you're resisting a transfer of living arrangements, again, this is something that you really need to be alert to and to flag up to the court that has this really been thought through, and are we not just moving the problem. So again, Re-H is a very good case in relation to that. So in summary, and I'm sorry I've gone a little over my time estimate, but there does need to be an absolute fixed judicial strategy from the outset. The transfer of living arrangements is by no means an option of last resort. It is a holistic, welfare-based decision. As soon as you can, you need to have a factual matrix, very often by way of a fact-finding hearing. Even if it's an interim hearing, you need some facts for an expert to work on that. That does need to take place. But be mindful, it's a cliche, but think outside the box in terms of the tools that you have at your disposal. For instance, as I say, not just the threat of a interim transfer of living arrangements, but very often wardship can be useful. So thank you very much.
I'll just get my screen up. All right, thank you, everybody. I was asked to, at the end, sort of mop up, and I'm looking at the situation from the point of view of the judge who first sees this case at an FHDRA with some pressure of time and often with two litigants in person. What would be really helpful at that stage would be to have a magic wand, but that's not what we have available. We have, from the judicial perspective, in many cases, very limited resources. So with one eye on the limitation of those resources, I'm hoping to just consider what we as judges are looking for and that might help us spot at an early stage these types of alienating behaviours. I said to Judge Rayside, I said, I find the term alienation a difficult one because I appreciate from what Dr. Breyer has said, it's a very specific type of parental conflict. But nevertheless, alienating behaviours, while they may not strictly comprise alienation, do in effect obstruct contact and damage the relationship between the child and one, or indeed usually both parents. So I thought what I would do is to have a look at some types of behaviour that might be flagged up at an early stage that would perhaps be set the alarm bells ringing for us as judges. And I started off by considering the sort of allegations that one parent makes against the other. The first one are those that are the serious relevant allegations of harm either to the parent or to the child. And at the FHDRA, we don't know whether there's substance in those allegations or not. PD12J would clearly be engaged very often in those cases, contact will not be happening at all. And clearly, those cases should be flagged up at the outset as essential cases for a fact-finding. There's no point at that stage directing a Section 7 report because the CAFCAS officer is not able to say when doing the report whether or not there is substance to the allegations or not, and therefore whether or not the contact is not the refusal of one parent for the child to have contact is the right thing or not. So they need to be dealt with as a matter of urgency. I agree with everything that's been said in relation to that, and a fact-finding listed. Whether or not the simple allegation is that the child has been alienated, or whether or not it's more helpful to set out the alienating behaviours. In my view, the alienating behaviours are more helpful because just a general term of alienation doesn't really assist, particularly with litigants in person, in a fact find. Then we have, I think, situations that we often see, which are where they're often historic allegations or allegations of things that have happened around the time of separation. Contact has been taking place intermittently, it's difficult, it's inconsistent. The parent who's having the contact says it's good and the child is happy, and the resident parent says that the child doesn't want to go, and in fact contact should be reduced or there should be no contact. In those cases, it's very easy sitting as the judge or the bench to say, well, look, contact's been happening, why do we need a fact find? But actually, if there are allegations sort of lurking in the background, they will persist. They will persist until, and you will never get a good resolution to that because they will continuously be raised by one parent. And so I think you either need to have a fact find, or it needs to be made very clear to the resident parent that if they don't want a fact find, and sometimes they don't want a fact find, they can't raise those facts as for the future. And that needs to be clearly recorded, that that is the decision that the parent has come to. And that they can't have their cake and eat it. They can't raise the allegations and use them to limit contact, but on the other hand, say that they don't want to have a fact find. And then the third situation, which I think are very difficult, is where you've already dealt with the allegations, but they are consistently repeated. And they're repeated to CAFCAS, they're repeated to Children's Services, they're repeated to the GP, and never is it said that they have been dismissed by the court. And those are really insidious, those allegations. And certainly I've made orders for copies of my judgment to be provided to the GP, to Children's Services, to CAFCAS, to really diffuse that situation. And then you've got the situation of new allegations that are made just before a hearing or just before contact is going to change and be increased. And those, again, you have to deal with, I think, quite robustly. I don't mean in this in any way critically, but quite often you'll find that a parent will raise these allegations often with the duty social work team. The duty social work team, who know nothing about the case, will say, well, of course, you must exercise your parental responsibility. And if you don't think contact is safe, then you shouldn't send the child to contact. And the resident parent takes that as a green light to suspend contact. And that's why it's really important that if you have got a judgment dealing with allegations and that you have made comments in that judgment about perhaps repetitive or indeed new allegations being raised, that is clearly with Children's Services. And in light of a recent case I had, check that it is accurately recorded in the chronology rather than being sent. This was not a local authority, but it's not sent to Children's Services only for them to file it and not record its existence in the chronology, because that's really, really unhelpful and allows these allegations to be made, contact to be disrupted, and the cycle starts all over again. So the next category I would look at, and this is a very broad one, which is what I call disguised compliance, where either there's been a contact order or the resident parent has agreed to contact. And in both of those situations, you find that while there has been disguised compliance, there's no real compliance. In fact, there are constant difficulties raised with contact from where the child's going to be dropped off or picked up, that they're not dropped off or picked up on time, that the locations are difficult, the timings are difficulty, that the resident parent is being forced, and that's a commonly used word, forced to make the child go to contact. And how are they supposed to do that? Should they lift them up and put them in the car? And then you've got the over-controlling parent who won't let the non-resident parent run their contact the way they choose to and enforce routines and food and application of sun cream and all the other controlling matters. Overuse of text messages and telephone calls during contact. Though it really doesn't progress the contact at all. In fact, it becomes makes contact so difficult that by the time you get to the next hearing, really no progress has been made. You also have the parent that organises activities during the other parent's contact. The child now is going to be the next, Olympic horse rider or Covent Garden ballet dancer, and they couldn't possibly miss their horse riding or ballet dancing or their best friend's party or some other thing, which in the child's mind is then prioritised over and above the contact with their parent. And in my view, if you've had a matter that's come back several times, you've had no progress with contact in spite of the agreement or the order for contact, that should really raise a serious red flag because another order is not going to improve the situation. The resident parent is in effect making the non-resident parent literally jump through hoops to try and have their contact, and it's not a pleasurable experience for the child, and the child perhaps decides that this is not something that is enjoyable and perhaps they don't want to do. Possibly for perfectly good reasons, because it's not enjoyable, but the reasons it's not enjoyable are because of the resident parent. And then I think you've got a parent who perhaps isn't even understanding that they are obstructing contact or making the child alienated. And I call that the parent who's got too close a relationship with their child or their children, the enmeshed parent. And here where you've got contact that's been agreed or ordered, but the child doesn't have any emotional permission to enjoy the contact. So they're anxious about the resident parent when they're away. I had one case where the children when they went to contact, they had to take a scarf of their mother's with them so that when they stayed over, they had mother's smell when they went to bed. These were young people who were 10 and 11. They didn't need to have their mother's scarf, but they took it because she did. You might have a resident parent who's worried about their own relationship with the child, whether or not that's going to be somehow diminished by the children having a good relationship with their other parent, or where because of perhaps the arrangements on the breakdown of the relationship, there is a real resentment maybe the resident parent's only control in the relationship is the children, or there are financial issues. So there can be all sorts of reasons why it's difficult and sometimes almost impossible for the parent to give that emotional permission. And those situations, often children can't come back to the resident parent and be open about what they've done, or to say they've had a good time or they've enjoyed it. And in fact, quite the contrary. So that's my sort of rough and ready things to look out for. But having looked out for them, what are we as judges supposed to be able to do about them? Well, I think the first thing is to be proactive. Try and spot these cases at an early stage. And that's easier said than done, I know, because very often you have the FHDRA, there are no real safeguarding issues. There may be some sort of maybe some suggestion that perhaps the children aren't very keen on going to contact, and you make an order for a Section 7 report, because at that stage there doesn't look like there's anything that's particularly unusual other than just parental discord. And you'll then wait 12 weeks and you get your Section 7 report, and that may then alert you to the difficulties in more detail. But you're then 3 months down the line, and by the time you then get statements and maybe police disclosure, it wouldn't be clear, you're then some further months down the line before you even get to a fact find. And I think it's very important that we as judges are, and hopefully assisted if parties are represented, by having more information at that early stage, so that we can get to grips with them. And as Richard said, we can case manage them and get a handle on them, so that it's really clear what the route map is going to be. And to that end, I agree entirely with what's been said. We must have some judicial continuity, because otherwise the parents who are obstructive simply tell the same old story to the next judge who listens to them, and then the next judge who listens to them. And you really need to get a grip on these cases and say, oh, no, I've heard that before. You already know what I think of that argument. Move on to the next point you've got to make. And tied in with that, I think, are the cases where they're quite rare, really, where parents have some money and they agree to go off and have some sort of therapy done or some work done. And it may be that the obstructing parent is actually simply paying lip service to that. It's another delay, and you can find yourself a year down the line with no real progress, although on the face of it, the parties are in agreement with the process that has happened. Get some help. These are difficult cases, they're challenging cases. You will have CAFCAS who will hopefully assist you with a Section 7 report and some further advice on where to go. Trouble is, in many of these cases, there isn't any money for those additional services. Children's services, I've had mixed experiences of children's services supporting these types of cases, unfortunately. And particularly, as has been already noted, the reliability of children's wishes and feelings, and perhaps social workers and indeed family support workers who are not experienced in these cases, coming back and reporting the children's wishes and feelings, or, and the phrase I really don't like is taking things at the children's pace. Well, the resident parent really means by that, never. It'll never progress because the children don't want it to. You know, they don't go to school at their pace, do they? They go to school whether they want to or not. So I think we need to be very wary of these, in these cases, putting a weight on children's wishes and feelings, or indeed taking things at the children's pace. Get on with your fact find, and having got on with your fact find, make sure you've got a clear and robust judgment, which makes clear findings. Even if you don't make a formal alienation finding, you can make a finding that one of the parents has engaged in alienating behaviours, with the consequence that the child is not having the contact that he or she should be having with the non-resident parent. Make sure that anyone who works with the child or the family has seen your judgment and has access to it, and it is clear the findings that you have made, and that the parents understand that in a fact finding, if you don't find that something happened, as far as the court is concerned, it didn't happen. So you don't want to hear about it again because you found it didn't happen. And I think it would be really helpful if both CAFCAS and Children's Services took that into account, that judgments, if something if a fact is not found, then as far as the court's concerned, it did not happen, and the court process must proceed on that basis. If there aren't any safeguarding issues and you've had the at an early stage, but so you don't need a fact find specifically unless you've got alienating behaviours that you're going to deal with, you might want to consider those early interventions. So I've called it child contact intervention. It's now called something different, particularly if there's been no contact at all, because that might be enough to break the deadlock, or as Richard's talked about, the external agencies, for example, the Anna Freud Centre, or indeed other psychological intervention. But they are really expensive, and many parents simply can't go down that route. So you are looking at the support that can be offered from CAFCAS or Children's Services if they will take on the case. And then consider a guardian for these children. I know here in Surrey that CAFCAS have difficulties providing 16/4 guardians, but NIAS will still provide them, and think about getting a guardian on board sooner rather than later. Don't do it 2 years down the line when you're really stuck and everybody's stuck. Try and get that guardian on board, because you may find that the early assistance will help. I've talked just briefly about enforcement because this comes back time and again. Frustrated non-resident parents issue their C79, contact's not happening. Well, what do you want the court to do? What are our options for enforcement? Well, really very limited. Most non-resident parents don't want to send the resident parent to prison because that may alienate the children even further. There isn't any really realistic options. Possibly if the parent has some money, you might be able to effectively make them pay compensation for wasted contact journeys. But it's a very unuseful tool, really. And then consider that the change of residence, and I would completely concur with Richard that it's not the last resort. It's based on a welfare analysis of what is in the best interests of the children, and those best interests being your paramount concern. And Richard's already touched on the issue of a suspended order. Occasionally, you might make an interim order to change residence. And certainly I have a case at the moment, I didn't make the interim order, but an interim order was made after a number of contact orders had been disobeyed. And then finally, if you are going to order change of residence, you need to plan it. You need to know how it's going to be executed. How is this child or children, how are they going to be moved from the parent with whom they are identified, the parent with whom they have probably lived all their lives, and then be moved to somebody who in their eyes is not, as far as they're concerned, a good enough parent to them. And they may have stronger feelings than that. So how is that to be done? And when I say how is it to be done, how is it practically to be done? And I speak from recent quite bitter experience on that one. You know, how are you going to get those children from one house to the other? And having done that, what support is going to be put in place for that child or children? Are you going to have the support of children's services? Would children's services provide a bridging placement for the children? And then what are you going to do about contact? You're going to have to decide, if you do change residence, are you going to make that your final order? And if so, what's going to happen about contact? Because sure as eggs is eggs, the matter's going to be back when the issue of contact arises. Or are you going to, in effect, continue the judicial oversight of the case in order to ensure that contact takes place the other way round, and you don't get a different form of potential obstruction or alienation? And that finishes me. I'm sorry, I've been a bit longer than I said I was going to be.
Thank you very much indeed to all our speakers. That was absolutely fascinating. I think we were ambitious, thinking we could tackle such a difficult subject in an hour and a half. In fact, we could have had this conference over a day, it seems to me, and we've had some absolutely fascinating questions put on the chat and on the question bar. I'm just going to, because of time, I'm just going to choose 3. Of course, I know people can just drift off, and that's fine. And thank you for those who have been with us and who have to go. I quite understand. I'm just going to ask for 3 questions to be answered. I'm afraid these are ones that have interested me. That's why I've chosen them. Janine, we've been asked, there's somebody who seems to be a professional working with a family where a very young child is so traumatized by the prospect of seeing their parent that they seem to be threatening suicide, and that seems to have put everything on hold. Can you give any advice, or obviously not the specific case, but indication about how people should proceed? Should they give up, I think is the question.
So I think the answer is obviously so case dependent. And I have one particular family in mind recently that a number of experts panicked when the child was threatening suicide. And in fact, they didn't go ahead with it, which was actually a pity, because the child now does have contact. And the interesting thing, however, is that the pattern has been repeated with the sibling who is also self-harming, but is anorexic to the point of starvation as soon as we tried to go in with the contact trial. So, and this is a case in which the judge had already found alienation. It's perfectly obvious. And the answer was we had to withdraw. We actually had to withdraw because the hospital were against, because what the hospital did was then create a primary attachment with the alienating mother, when actually it was all going in the wrong direction. It was terrible. Saying that, it's not uncommon for children to present with suicidal threats. And this is what I'm saying about it depends on the individual case. And I would say generally not to panic. You can actually see children threatening suicide, and then literally, if you put the right thing in place for a transfer, 4 days later, they're absolutely fine. But it just so much depends on the quality of the attachment. How long haven't they seen the parent for? What are we seeing here? Sometimes I've seen children threatening suicide literally, and then we're talking about half a day later, they're perfectly fine. And that's what I was trying to say, that the contrast, but saying that, you know, if the child hasn't seen, the child is 15, hasn't seen the parent for 3 years, it's very, I'm sorry to not answer the question effectively, but it's so case dependent. But I would say generally, in principle, don't panic, but analyze it very carefully and see whether actually in practice, if the attachment is strong enough and you've got the right facility, and you can put in place, I've suggested put in place the kind of 24/7 monitoring, make sure the child doesn't have access to ligatures and all the rest of it, to treat the child as if you would a child in danger, as you would in hospital, if you think it's going to work. But that's the question.
Thank you. So professional advice, I think, is the answer. And another question for you. Someone has asked a very interesting question about whether there have been any long-term studies in how children who have been the subject child, if you like, in these cases have felt at the other end, maybe as they reach maturity? Do they feel guilty about the fact perhaps that they were how they behaved and so on?
Yes, I mean, it's very interesting because you have a long period of dormancy where the child is aligned, it lives with the aligned parent, may even have seen things or experienced things, but then have a loss of memory, don't remember. And then they decide in their 20s to start looking back at what's happened. And they start having problems or issues with the aligned parent, and they start looking into it. And it's a very delicate time in which they can feel a lot of shame and depression. So it doesn't happen during a very extended period, necessarily during adolescence, because they're not necessarily aware of it, but it does often happen in their 20s. And Amy Baker is a good book to read on that. She has done a lot of work, retrospective work on the experiences of adult children who were alienated as children. And this is where I was giving the evidence on depression and the huge rates of depression, the shame, the things that they've felt terribly guilty about, their behavior towards the targeted parent, which is something important for the targeted parent to know and understand, that the child, is not and needs that kind of, they need therapeutic support in adulthood. And sometimes I've seen some wonderful reunifications with targeted parents where it's worked really well in therapy, and they've kind of apologized, and the parent said there's no need, I totally understand, it wasn't your fault, you were the child, and things. But yeah, good work. Amy Baker, 2011, I think, breaking the ties that bond, or breaking the ties, can't remember, but Amy Baker has done a lot of research.
All right, thank you very much. Finally, Lisa, I think this is a question for you, although I'd be interested in it if any of the other panelists had an answer. A professional who I think from the question might be a social worker says that they're doing some work with a mother who is in a refuge, and the refuge have become, that there's an allegation that the mother is alienating the children. And the refuge have said to I think probably a social worker, that the term alienation should not be used. This is obviously tied in with protection of those who are victims of domestic abuse, because it's thought that alienation is used to undermine often women who say they've been victims. Yes. Do you want to comment on that? Because it's actually a very topical and sensitive issue. Have you received?
It really is, and I think it goes back to what I think all of us have said about a fact-finding hearing, because how important it would be for professionals to have a matrix. So, if this mother is in a refuge because of experiencing domestic abuse, and she is fleeing, and the children are fleeing harm, and there's a risk of that harm increasing because of our intervention and trying to send these children off for contact when they're traumatized by their experiences, etc., versus somebody who is using is making false allegations about domestic abuse. And it's very few and far between, and I want to be sure that that our starting point is that we want to hear those stories, and we want to fully assess the allegations of domestic abuse, put them in front of the court. The court needs to give us a fact-finding hearing and give us a factual matrix to work with. Because that social worker is stuck in a very difficult position now, because rightly some people are saying don't use that term, it's undermining this mother, and it could be, but it also could be the other side of the coin. So yeah, straight back to that fact-finding hearing.
Can I just say that I agree with that? I think when you've got serious allegations, you've got to bottom them out before you can take the matter really any further, because the allegations may be proved.
Well, quite. It's just difficult when the terminology, when the terminology becomes contentious. Richard, you were going to say something on that one.
I just wanted to add that it would be idle to deny that the term parental alienation can be used, quite frankly, as a sword or as a shield, in terms of people are either defending themselves, or of course people are just sometimes making allegations with no foundation. And I think it's not a case of saying to people, well, you shouldn't be using that phrase, but even before the fact-finding hearing, it is a question of evidence. And I think If, as happens, the term parental alienation is weaponized as a term, and a parent finds that they're on the receiving end of such an allegation with no basis, there's a couple of things. First of all is, of course, you just need to evidence all that you are doing to promote a relationship. But I think you need to spell out, if you're in that position, well, actually, this is a form of abuse itself, that this is being alleged in a groundless way. And it is done because it is done as a term of abuse. And sometimes that is true. And there is nothing more stark when you have a parent who is genuinely doing all they can to promote a relationship, and you have an abusive parent who isn't listening and doesn't want to listen, and actually at times doesn't even want a relationship with the child. They just want to use a term as a form of abuse. And again, evidence must be quite literally flushed out to identify those cases. So yes, even before you get to the fact-finding hearing, I think it's a question of evidence, evidence, evidence.
All right, well, that's absolutely fascinating. We could go on for a long time, but home calls. I'd just like to thank everyone who joined this evening for giving up your time. I hope you found it interesting and informative. We've had some lovely comments. I'm sorry we couldn't deal with more questions, but we have to let our speakers go. A huge thanks to our speakers, to Dr. Brer, to Richard Jones, Lisa Pauling and Judge George, and a huge thank to 1GC Family Law, thanks to 1GC Family Law. Just because a few people have asked, and I'm going to repeat, that the link to the talk has been recorded and the links will be sent out to participants, I hope and think tomorrow, so that the information is there and you can access it in that way. Thank you very much, and good night from Surrey.